So our next session is going to be the HIP Hacker's Guide to Policy. I think I got that. Yep, the HIP Hacker's Guide to Policy.
If you're not hip, if you could just leave now.
Yeah.
Thank you.
There's a couple I saw on the way. So just before we get started, I would like to thank our sponsors here at BSides, who have kindly made this all possible. So where is my sponsors spiel? So we especially want to thank our diamond sponsors, LastPass, Palo Alto Networks, and also our gold sponsors, Amazon, PlexTrack, New Vision, Google, etc. So we'd like to thank them for their support. Without them, these conferences, these events aren't made possible. So moving on, getting into the next area, I'm going to hand over to Josh, who's going to conclude with the introductions for this session. So thank you, Josh.
All right, home stretch. Excellent first day. We usually try to do a policy refresh of like what were the wins, what's the pending legislation, or what's the attitude towards hackers. We've kind of had some interruptions over this thing from COVID or whatnot. So the bad news is we haven't had an update in a while. The good news is a lot of really important stuff happened, including passing a law, including you're going to hear from prosecutorial discretion for good faith research. So we want to have that.
Hey, no spoilers.
Spoilers. But I mentioned this morning, and this is a perfect example of why to do it. I mentioned this morning that if you watch the Cavalry launch 9 years ago, and it's on video, one of the things, you have to put yourself back in a 9-year period. Edward Snowden just happened. Distrust between government and hackers had never been higher. We had seen some cyber physical systems hacks and stunt hacking on certain things, but we didn't really have any trust built. And one of the deep concerns that Nick Percoco, our co-founder, had was that we're going to see increased criminalization of good faith security research. And that was a very possible future. And don't just get an update of what's happened in the last 2 years. It's stunning to see the plan that we had in place 9 years ago and how it is actually matriculating, and now how much embrace we have seen. So we have 3 amazing panelists here, and they will introduce themselves because they are funnier than I am. And but look at this not only as a milestone for what's happened over the last 2 years and where things are going, but just think how far we've come in 9 years and think how much further we could go if we double down. All right, so let's welcome our panel.
Thank you very much. And just as a little public service announcement before we get into this one, are you good? Can you hear me? Okay. I don't know what that means. So in one of the earlier sessions, people were talking about ransomware a whole bunch. For those that are going to be at DEF CON, and I do know it's a party foul to mention another conference when you're at one, but there will be a session in the policy department on government responses to ransomware. It's a 2-hour discussion. It will involve the UK, the US, and Australian governments, and they want to hear from you guys. So if you have ideas on things that are not being done that should be being done, or you want to hear what the stuff is that they're already doing, that session will be on Saturday from 4 to 6 in the policy section at DEF CON, and I apologize sincerely to all of the lovely B-Sides people that I've referenced DEF CON. But it is an opportunity to speak with the government attendees on that topic. But that's not what we're here for today. So we're gonna do a what's happening in policy land. And there are 3 sort of things that we really wanted to cover, which is how does it all work? How does policy work? What are the different parts of the government doing? How do they work together? All of that kind of stuff. How can you guys get involved? How can you help influence it and create positive outcomes? And then what's the stuff that's actually happening? What's the status quo with things? That kind of thing. To get a bit of a level set and make sure that we're using our time wisely and in the right areas that are going to interest you, how many people in the room feel that they're pretty sort of up to date and cognizant on how the process works and how's the sausage made? What does policy look like and all that kind of stuff? Who's brave enough to say that they think that they are? All right, so it seems like we can probably spend a bit of time on that, and some others will find that useful. Awesome. Thank you for playing. Okay, so I'm Jen Ellis. I am Rapid7's VP of Community and Public Affairs, a title that no one knows what it means, myself included. And I work a lot with governments around the world on how do you advance security for everybody, right? How do you create societal change? That is what I do. It's my accent.
Okay.
And also that I don't know how to use microphones. Okay, I'm just going to awkwardly lean forward. It's funny, actually, because normally I'm told there are people who can hear me in the UK without a microphone when I'm in the US. So we're going to talk about how policy works, how you guys get involved, and what's going on in policy land. Josh mentioned 9 years ago when the Cavalry started. And funnily enough, 9 years ago, Josh and I were at DerbyCon. And we sat down, and Josh went, I'm starting this thing. I'm really worried about the intersection of physical and virtual and the potential for it to create harm. I'm starting this thing. And I was like, I'm starting this thing. I'm really worried about the legal impact for security research and the chilling effect. And we looked at each other and we were like, are we starting the same thing at the same time? What is that? And then we realized they were super complementary. Not the same, just super, super complementary. So we ended up kind of on the hill, going and talking to policymakers, and I would reference his work and I would reference the Cavalry in my briefings on security research because, it was a great opportunity to talk about the importance of security research when you can say, and researchers are these great protectors who want to save the world and protect people from that intersection of, I'm going to use a Josh Cormanism, where bits and bytes meet flesh and blood. And so I was able to talk him up and, I'm going to just give him the benefit of the doubt that he did the same for me. Okay, so that's a little bit about me. I'm now going to hand off to Jack and Leonard to introduce themselves.
Sounds like I'm being volunteered to go first. So I'm Jack Cable. I am a security researcher, which is what we call hackers when we're talking to policymakers to make them less scared of hackers. So if you haven't caught on yet, that is a good tactic to make people think you aren't like this scary figure in a hoodie, even though you are. So I have worked in a number of government agencies, including CISA, U.S. Cybersecurity Infrastructure Security Agency on election security, Department of Defense, working on their Hack the Pentagon program, which was bringing in hackers to help secure the U.S. government through bug bounty programs, and most recently doing a fellowship in the Senate. So kind of spanning both the executive branch and legislative branch, and looking forward to our conversation today.
And good afternoon. I'm Leonard Bailey. I am Special Counsel for National Security and head of the Cybersecurity Unit, which is what I call myself to make sure I don't scare hackers. I'm also, I guess, a prosecutor federally. I've been at the department for 31 years.
The suit gave you away.
I know. I guess I said to Jen, I tried to make Spot the Fed as simple as possible. So, I've been working in this area for about 20 years, and I've been in the department in a lot of different capacities. I will say that conversation about chilling security research, what happened there was I think it was 2014. Jen and some colleagues came to my office, the Computer Crime and Intellectual Property section, and basically said, your ways are strange to us, but they're chilling research. And the chief of my section heard that, and he said, we don't want to do that. We think there's legitimacy to having people who are trying to solve the problem on the playing field. And so we embarked on what has been a multi-year effort, and we'll go over some of the high points over that time, to figure out how we could better message what we try to do, which is actually try to go after people who are trying to victimize others, rather than, at worst, people who are trying to do the right thing in the wrong way. Just
to add to that story, so that meeting happened towards the end of June. And during the course of the meeting, when they didn't instantly throw us out and tell us that we were idiots, we said, hey, if this is a thing you're interested in learning more about, there's this thing happening in Vegas in a few weeks. You guys should come out and we'll introduce you to some people you can hear about it firsthand from researchers. And they looked at us and they were like, Vegas? We're the Department of Justice. And you said weeks? And then a month later...
In August?
A month later, I get an email from Leonard saying, I've booked flights in a hotel, can we still do this? And it was the first time you came out to Hacker Summer Camp, right? And he has been here every year since. That's 9 years.
Even the last 2 years, I was really lucky. Right. It was just sitting here.
All right, not then.
Yeah.
And he has spoken every year since, because he has made a huge effort to basically try and build a bridge between his community and our community. And I think Jack does the same thing from the opposite side. As a researcher working in government, he's building that same bridge. And I just think these touch points, these sort of entry points and these points where we create this two-way dialogue are super, super, super valuable and important. So I think these two people being on stage is just incredibly important. And I would actually like it if you would give them a round of applause for the work that they do. Thank you. It's deserved. It's deserved. All right, now we'll get into substance stuff now that we've done the cheesy moment. So you were going to do, I think, like a little bit of a how does it all work together?
Yes. So I'm sorry. I'm gonna get a little schoolhouse rock on you for a moment because I want to talk a little bit about how the government works. And I imagine a lot of you are familiar with the government. But the last few years has, for me at least, suggested that maybe not everyone really understands how the government works. And so I wanted to just sort of break things down just for a couple of minutes. And how many of you are lawyers?
I'm a Juris Frickin' doctor.
You
does
are,
that matter?
that's right.
Does that,
okay,
does that count?
Only a couple. Good. Okay. So very quickly, obviously we have the three branches. We have Congress, we have the executive branch, and you have the judicial branch. Congress makes the rules. They pass the laws that tell others what to do. So, for example, the government can only do what is authorized to do. So we have to look for some statute or some authorization in the Constitution to do whatever we want to do. We don't just get to do what we want. We have to have it moored in some statute or some authority in the Constitution. So the executive branch, not surprisingly, executes the law, right? So we do what Congress tells us, what they authorize us to do. And then, though, there's this one little space where we kind of get to make law. Generally, the executive branch does not make law, but in discrete areas, Congress is able to say, hey, look, there's this issue, it's complicated, we're going to give you the guardrails on what we want you to do, but you fill in the rest of it. And that's essentially what the regulatory authority of different agencies are. So you have like the FTC, right, the Federal Trade Commission, or the FCC or the SEC, or independent agencies, where Congress has said, okay, you deal with publicly traded organizations and you come up with guidelines, that's your mission, go. And that agency is able to make up rules that guide that. And they have a rulemaking process where they have public comment. They invite people to comment on the rule they're promulgating, and then they take that in and they produce a rule. And then sometimes people say, wait, you're now exercising too much authority. That's past what Congress said was okay. And so you may have the judiciary step in, which is not supposed to make law, but is supposed to interpret whether the law is being faithfully applied. So they're supposed to essentially say, wait, you've overstepped your bounds, and you will have to stop that. Now, this is an elaborate Rube Goldberg device that is not built for efficiency or speed, right? The whole purpose of this is to make sure that there's no institution or individual who has so much power that they can essentially assert tyrannical rule over other parties in the system. So this is the way these sort of checks and balances work. It's messy, but there are opportunities in each of these channels to have some policy impact. And we're going to be able to talk a bit about that now. But I just want to lay out these areas.
Yeah, and I think, you talked about how Congress can set boundaries or guardrails, and then there can be an ongoing role. But that also happens on a project basis sometimes, right? So like we saw that with something like the IoT Cybersecurity Improvement Act, right? Congress passed the law and said, but NIST is going to figure out the details. And we just saw it recently with Cercia, right? Same thing. This is incident reporting, where Congress said, hey, we need to have incident reporting, and then it's like super important, let's pass law on it, and then let's give CISA 3.5 years to figure out the details. So which I'm sure CISA is working on super urgently. Yeah, perfect. So it happens for regulatory agencies, it happens on an ongoing basis, but then you also see it happening on a sort of ad hoc project basis, very much sort of hand in hand with the law passing process. And it's important to understand those two halves because you can influence them either side of the law passing potentially, if that makes sense. Okay, anything anything else on like how it? Does anyone have any questions on the how all these parts work together before we move on? Okay, all right. So we talked about like all the different pieces. I'm going to ask you, Jack. Like, let's talk a little bit about how people get involved. How do you work with these different parts? Like I just said, you can work on either side of the law being passed. How? What does that look like?
Yes, so, and I think a starting point for this, and of course I'll start with Congress, get into a little executive branch. I'm sure Leonard can go into that more. But in terms of kind of thinking through, and yeah, it goes back to the Schoolhouse Rock, I'll spare you the singing of it, but essentially how a bill works through the ways in Congress, but even broader than that, just the different tools in the toolkit coming from Congress. And kind of, yeah, we're all familiar with bills setting law, but beyond that, Congress has oversight functions where it can do stuff, it can hold hearings, it can write letters, it can ask hard questions. That's not setting law, but still kind of keeping the executive branch in check. So that's one area where kind of when you're thinking of, okay, how should this policy problem be tackled? I would encourage you to think broader than just say kind of would a bill solve this, but maybe is it due to something not working as well as it should be in the executive branch, is maybe something outside in the private sector that some more attention could be brought to, but kind of the different tools in the toolkit when it comes to kind of making policy. And then specifically with bills and kind of how to get involved, I think one area that at least wasn't clear to me before kind of I came into Congress was the importance of committees, where Congress divides itself up into different committees which handle different jurisdictions. There's, for instance, the Armed Services Committee, which handles all matters related to defense. Foreign Relations Committee handles matters related to foreign affairs. And in order for a bill to move that relates to one of these jurisdictions, it must get cleared by that committee. So that means that especially the chair, the head of the committee, and the ranking member, which is the top congressperson of the minority party, has a lot of influence in not only determining what bills get in or what bills don't move forward, but also say what's in those bills. So I think being able to kind of identify the, say when we're talking about cybersecurity policy, the committees that are especially relevant, a lot of those are, for instance, the Homeland Security committees in the House and the Senate, the House Oversight Committee, the Commerce committees, when you're thinking of, say, NIST or NTIA, and then the Armed Services Committee as well for kind of some of the, and intelligence committees for some of the more kind of intelligence community aspects of cybersecurity. So identifying kind of who the, say, staffers are there is one way to be able to influence more than, say, talking to a member who might not be on the relevant committee. And that's where a lot of kind of the relevant subject matter expertise lies as well on committees. So that's the Congress view. I'll let Leonard get into.
Just before we do that, just quick show of hands. How many people here have ever reached out to a member of Congress about a policy issue? Okay. And who did that by email? Who phoned? Okay. Interesting. Sorry?
Oh.
But how do you get the face-to-face? Did you meet them somewhere? Okay. Hey, I mean, honestly, the staffers are the people that get things done. So, and everyone starts somewhere. Okay. And of the people who put their hands up, how many of those were committee staff rather than your local representative? So the people who have talked to Congress, how much was it committee staff? So who went to committees, committee members or committee staff, as opposed to going to your local representative? Okay. All right, interesting. Thank you. You're up.
Okay. Well, so in the executive branch, it's a little complicated. There's no simple answer, and part of the reason I wanted to break out that regulatory agency issue is because those are agencies that have a ready-made process for people to get involved, right? So they do a notice that they're going to do rulemaking, and they solicit comment. And those comments actually truly matter in talking to regulatory agencies. It's not the question of numbers, because it's not about voting. It's about the sophistication and accuracy and rigor of the comment. And people with technical understanding of the way in which a law might impact a community or an issue actually have a louder voice when people review the comments. Obviously, 100 people saying this law sucks or this rule sucks, is not going to be as effective as someone who can dissect the rule, in a very exacting way and explain why it's a problem. And so in that way, I would say that people in this room, in sort of a rulemaking process, may have a louder voice in some ways than others who are commenting on something and would have something to bring to the discussion that others may not. Now, once you get outside that sphere, though, I would say that it's a little harder for anyone to just have impact on executive branch policymaking. I can say, like, for example, the Department of Justice, we're not an agency that takes comment on the things that we do, by and large, right?
But I keep offering over and over again.
She does. And so, it depends on how you want to make some impact. I will say, though, that there is some, people have succeeded. There have been sort of lobbying efforts of individuals in the administration, for example, in our Security Council or other places. And one reason I would just say that might make more sense now than it has in the past is because I don't know if you've noticed, but there's a certain bit of gridlock on the Hill that has made it harder to get legislation passed, right? As a result, executive authority is being used perhaps more often. You're seeing more executive orders that deal with specific issues like cybersecurity, and that's because it's something that the executive branch can do unilaterally. The one thing I'll flag about executive orders, though, that is not always well understood is that, again, as I said, the executive branch doesn't get to just make laws. An executive order has to be based on some statutory authority that exists, or it has to reside on authority that resides somewhere in the Constitution that's sort of the organic authority of the executive branch. So, if you're in the area of national security or foreign policy, the executive branch has kind of constitutional authorities there. But when you get to other areas, it really is a question of finding what the statutory authority that undergirds the executive order. If, though, you're in the space in which the executive can actually use an executive order, there's a good amount that the executive can do. And I think we'll get to specifics later, like the executive order 140. The most recent.
I was going to be impressed then, but
yes.
no.
Oh, good. Okay. The Biden cybersecurity executive order that came down in May of 2021. That's an example of basically the executive branch turning to its own personnel and saying, do better, and this is the way that I'm directing you to do that.
Just to emphasize one point that Leonard made is when you're kind of advocating for something, the more specific you can be, the better. So if you can say, rather than just saying kind of there's a problem here, if you could point to kind of the specific, if it's say a draft bill or something, point to the specific area and say, no, I think the reason this is wrong, and if you can articulate kind of the
harm.
kind of policy, the harm that might be there, and say, here's a suggestion for how you can make this better. Kind of when that gets to either the Hill staffer or the person doing the rulemaking at the agency, they can then kind of assess what you've said, and then they have kind of the solution right there in front of them, so they're a lot more likely to take that into account.
If you don't know the solution, that's okay too, though, right? When we started out and we were going to them and we were saying, hey, the CFAA is creating a chilling effect on security researchers, we didn't have an easy, and this is how you should fix the language. And actually, it was a really, really super iterative process, because it turns out when I kept saying, like, just remove the civil causes of action, nobody went, oh, that's a great idea. That's really easy. We should do that. even though they don't exist in any other country's laws. But yeah, so it doesn't, if you don't have a solution to offer, that's okay. You can say to the policymaker, I don't have a solution to offer right now, but I'd be happy to work with you on this. And I've been very fortunate. I have found that frequently people really appreciate that sort of iterative process and will happily work with you on it. Just before we move off this topic and move into like what is happening and what we've seen in the past couple of years, I think we mentioned a little bit things like letters that you can do, and they tend to have more of an impact if you have more of a sort of groundswell behind you, more people signed on, more amplification, that kind of thing. And so, as individuals sitting here, you might be thinking, well, how can I do that? I think this is actually an area where you can look to the Cavalry, right? Like if Cavalry has a community, it has a Slack channel. I'm looking at Josh to be like, it still has a Slack channel, right? A Slack workspace. If you see something and you think it's a potential issue and you're interested in it, it's a really great place to like put something out there and say, hey, has anyone else seen this? Is anyone else thinking about it, worried about it? You can come to Josh or Bo. You can email info@ and say it, and we'll take a look at it. And if there are people interested and we think it sort of aligns with Cavalry's overall goals, we can help draft a letter, right? Like that's a thing that could come from I Am The Cavalry, which then has perhaps a little bit more impact than coming from, Joe Blogs on their own. And not only can we like maybe do something from I Am The Cavalry, but it turns out we actually know a lot of other people. We know a lot of other organizations, and we can go around to some of them and say, hey, we've got this letter, would you potentially be interested in signing on? Which we do all the time for letters, right? And so you don't feel like you're in it alone. There is an amplification effect, and there is power in numbers of people in this room all working together and collaborating. And I think that is really what the Cavalry is all about, is sort of harnessing that sort of strength that you guys all bring with your individual passion and knowledge and expertise, but all together we can create more from it. So just that was the last thing I want to say on that piece. And then we'll get into what's been happened. Nothing's happened, right? It's been a really quiet few years. Nothing's happened. So should we start with security research, since it is the topic of my heart? So how many people are familiar with sort of challenges around legislation chilling security research? Is this a thing that people care about, have heard about? You guys are my people. All right, so I think there are probably two main pieces of law that when I started on my little bandwagon 9 years ago were the sort of primary problems. One was the Computer Fraud and Abuse Act, which is the main anti-hacking law in the US, and the other was the Digital Millennium Copyright Act, which aims to basically protect copyright. I know that's my non-lawyer version. That's my Juris Frickin' Doctorate version. And I will say over the past 9 years, we've made decent progress on one, less progress on the other. We always knew the other one was going to be harder. So the Digital Millennium Copyright Act has an exemption now for security research, and it has had that since 2015. Yes?
Well, yes.
Came into effect a year later. Yeah.
2018, actually.
No, they re-upped in 18, and then they re-upped again.
In 21.
Yeah, so it's been re-upped twice. Yeah.
15 the first time?
Yeah.
Wow, okay.
Mm-hmm. This is why I have a Juris Frickin' Doctorate.
That's right.
So because they passed it in 15 but said a year, and then it came in 16, I think. I'm terrible with years, but I think that's right. I'm believing Amit, who is a lawyer, and she's saying yes. So it's got a little stronger every year, which is the good thing, right? They've removed some of the boundaries. Part of the reason for that has actually been support from the Department of Justice, who've written letters in support of it. I think more recently we've seen NTIA in support. I think FTC have been in support. I think maybe recently CISA's been in support. So there is there's an increasing government understanding of the importance and the value of security research, and we've seen it represented through this sort of rulemaking process that re-ups every 3 years for the DMCA. So at this point, if you're a security researcher and you own the technology and you're testing it in a non-production environment, then, like, you know, as long as you're not breaking a bunch of other laws, you're probably good. That's a huge step forward from where we were, honestly. Like, it's a massive step forward. And we've seen actually a shift in the attitudes of a lot of companies who make technology in understanding that that was coming. Like, I remember quite clearly being in a room with a bunch of technology manufacturers who had previously been pretty anti-research in 2015, and then them being like, we're all working on building our vulnerability disclosure programs because we know it's coming and we know we can no longer use the DMCA. So we have seen like a bit of a shift there, a cultural shift. The Computer Fraud and Abuse Act was always going to be harder to change. And so one of the ways to look at influencing it was to look at how it was being used by prosecutors. Leonard?
That's us. And I want to circle back to the DMCA for just one moment, because I think that, understand that it was a rulemaking process, like we've already discussed. There's an odd statutory provision in the DMCA on the circumvention of copyright protection in section 1201 that mandates a triennial process. Every 3 years, the Library of Congress has a rulemaking process where they ask, are there more exemptions that we need to create here to further these goals? And one of the suggestions was a security research exception. We did weigh in. We did something we don't usually do. We submitted a formal letter in support of the exception. And as the folks who actually enforce the criminal provisions of the DMCA, we had the Library of Congress actually listen to us. And so there was, at first, the creation of an exemption and then some expansion of it subsequently. On the CFAA, a little more complicated, because the DMCA, typically you're working on something, a piece of equipment or software that you possess, right? It's in your possession. When you're dealing with, let's say, pen testing, remote, testing of a server that doesn't belong to you, things get a little hairier, and and we actually are a little more skittish about that because the potential of there being a problem is a bit greater. Now, we've talked about legislative fixes, and we've found it kind of difficult to figure out how exactly you carve out research without also providing people who are trying to do bad things a ready excuse to still continue doing bad things under an exemption. But what we did end up doing and announcing in May of this year was through policy. So my office reviews every indictment for a CFAA prosecution across the country. And so we oversee the statute.
Which wasn't always the case, right? That was in itself a policy change.
In 2016, the department made that shift to create greater uniformity on how the CFAA was being applied across the country. And so, we have the opportunity to promulgate policy in this area, and what we have issued, and it's publicly available online, is direction to the U.S. Attorney's offices, the 94 districts across the country that prosecute federal cases, that they should decline prosecutions where there was good faith security research, and that is sort of the accessing a system for purposes of testing, investigating, or correcting a security flaw or vulnerability, where that is done in a manner that does not endanger public health or safety, and where it's done for purposes of improving security. And so that's essentially what we've been trying to get done in legislation, but it's very difficult to do, frankly. Here I will make a pitch to all of you, and this is a hobby horse I've been on for years. I think there's one way you can help us help you, and that is beginning way back in 2014 when I came out and talked to security researchers. I was told and convinced that basically having the department come in and tell you how you should do what you do is not going to go over really well, right? That's not going to really take hold. But having the community articulate norms and standards about how security research is supposed to be done, what it's supposed to look like, would allow us better to be able to distinguish between people who are doing the right thing and people who are actually not. And it's not clear exactly what the vehicle for that is, and I've talked to different people about this, but it's something I would encourage the community to kind of consider and think about. There's some way of giving form to that.
I'm just going to say momentarily that guidance that DOJ issued is a really big deal. And so...
And we had a question over here. Did you have a question?
Yeah, how would you describe that regarding like the techniques or the how or process of capturing that the research? In my opinion, I think that it's the intent, because the how to is the same whether you're doing it for the reasons to help an organization or a public organization discover the vulnerabilities and associated threats and risks. But the intent of how to use that information down the road differs. And isn't that what the DOJ and the judicial branch tries to prove in court of law? Is not so much what they've done, but what the intent behind it?
Yes, we do. We also, though, assume that what we're assuming about the intent of the actor is, in fact, the intent of the actor. So building that into the tests seems like it makes some sense. I don't know, at least to us.
Can you repeat the question? Or repeat the last phrase?
That us assuming an intent of the actor seems, even though that's something that we ultimately have to prove, that is what we would want to be the actual intent of the actor. And that's why it's reflected in the standard we use, regardless of what perhaps the individual is intending. I mean, we will want to understand, we want to believe that that's what they're doing. We want the evidence to support that's what they're doing. Ideally, that is in fact what they're doing. If they have a different motive, then we're concerned that there may not be.
But the distinction you're making is 100% on the money, right? This came up, like we've talked about this for 9 years, and we've looked at like different ways of drafting language because we haven't given up on the CFAA, or in fact other anti-hacking laws in other countries. Like I've been working on the CMA, the Computer Misuse Act in the UK recently, and what you're saying about looking at intent. So in the UK law looks at intent. Did you intend to do a thing, but not motive? And so you could say, I intended to access that system without permission, but I did it for like all the right reasons because I'm a researcher. And they're like, oh, we don't care. You intended to, and it's against the law. And so, hi.
We had a speaker request for survival instruction on surviving the zombie apocalypse.
It was really for these two. I just wanted them to be prepared.
You each get one. You don't get to opt out of it.
Oh, that's fine. Thank you. This is great. I'm very happy with this. Thank you. Thank you very much.
Let's see.
This is amazing.
That's me. Thank you.
Fantastic.
Thank you.
Thank you so much, Damon. We appreciate it. I was really hoping they were going to make them run. Fantastic, thank you. So we've been having a lot of conversations around that exact thing of like, if you, so for example, I am very passionately anti-private sector hackback, but I'm very passionately pro-security research. Often, the activities that you undertake could look the same for those two things. So how do I draw a line between them, right? Exactly as you say, if you're looking at it just based on activity and you're missing out that piece around motive, it's a problem. But it is a challenge because you've got to work within the framework of the law and what it actually acknowledges and looks at. I think, one of the things with the US version that we struggled with is if we said, hey, one condition or one characteristic of good faith security research is that you disclose your findings publicly, what happens if you don't find anything? Right. Are you basically saying like if you didn't find anything, you broke the law, but if you did find something you didn't, that's not very fair. So it is really hard to find language that works on this, which is why 9 years later we don't have an exemption for the CFA yet.
Even stories regarding that there has been some research in this field. We discovered vulnerabilities.
Yeah.
They were not exploited, yet they were prosecuted. Whether you could attest to this or not, but you're a prosecutor. They were jailed. The research was recovered to patch the vulnerability, but the person was prosecuted nonetheless.
So I would be interested in knowing what that was, because to our knowledge, and CDT has also done the same scrub we've done, we don't know of any security researcher that's been prosecuted in the last decade other than arguably Weave for the 2012 AT&T incident. Now, I don't know if it was a state prosecution or something else, but I'd be interested just to make sure that our understanding is right of what's going on.
Yeah, we've also done research on this, and we don't have cases. There are state laws for
There are
sure,
state laws, right.
and actually, interestingly, Washington's equivalent of the CFAA actually does have a security research exemption. It's the forefront of state laws on that. All right, we're going to take some questions. I do want to cover off some of the other laws that. Yeah, sorry, Jack.
The question marks run out of power. Can you repeat?
Yeah,
the
sure.
questions when they're
Absolutely,
asked?
not a problem.
No,
Yeah,
that's,
yeah,
thank you.
no worries.
Can I piggyback real quick off that last comment? So you're obviously speaking from the federal side of things. Are you providing guidance or working with states or other local municipalities? Because obviously there's that famous incident from late last year
Yeah.
where people
Yeah.
doing offsets at the state level. Are you working
Yeah.
with states to make sure that they're also having similar conversations at the policy side and legislative side? Can you repeat the question?
Yeah, so the question was, I think it was aimed specifically at DOJ. Is DOJ working with states to help influence their thinking around state laws and state prosecutions on anti-hacking and security research?
So to be honest, we haven't reached out in the manner that you suggested, in part because of federalism. Like states get to interpret their own laws, and but there is potentially an impact from. I mean, every single state that has a law that is something that addresses hacking is patterned after the Computer Fraud and Abuse Act, and so there is potentially sort of some impact on changing the way that the federal law is looked at and used.
Yeah.
And I'm sorry, the person in the back of it, I also want to make sure we don't lose.
Sorry,
that.
yeah, just before we move off this one though, also to say, while I think DOJ isn't doing a lot of it, people like CDT and the EFF and sometimes ACLU, they do. There are also people like, so my colleague Harley Geiger is the person who worked with Washington State to get the research exemption in. And so like that's why I know about it, because actually keeping up with all the states is super hard. And so if you, again, this is the thing, if you hear about stuff that's happening in your state, use the Slack, share the information, help raise the flag on it, and then we're better able to respond and to figure out, how to get involved and influence, hopefully. Sorry, Jack, go ahead.
Yeah, I do want to go back to a point that Leonard made earlier around creating norms for how to conduct this research, because I agree that that is kind of an essential area and one that I think we've made progress in. So shout out to Amit's work with Disclose.io, which is creating norms for both the researcher side, but then also for organizations to say, okay, this is how you can conduct security research against our company or our government agency. And in the absence of exemptions in the law, these often vulnerability disclosure policies are really essential to guide researchers to understand, okay, this is what you're allowed to do, including a legal safe harbor to say, okay, if you comply with the terms of our policy, we will consider this activity authorized and we won't take legal action against you. So kind of just doing that on organization by organization basis. And for instance, we've seen CISA issue a directive requiring all federal civilian executive branch agencies to start vulnerability disclosure policies, authorizing security research against their systems. So now you can go for pretty much any government agency. You could go for DOJ and look for vulnerabilities in them and be authorized as long as you comply with their vulnerability disclosure policy. We've seen this at the state level as well. Some states, Iowa, Ohio, South Carolina, for instance, authorizing security research with vulnerability disclosure policies for their election systems, at least those that you can kind of whatever websites on the internet. And private companies adopting this as well. So I think that is one area where we have seen progress in kind of organizations taking the lead and allowing security research against themselves.
Yeah, there's one in the back and then we'll come to you.
Wait 1 minute. We have our room mic working.
3.
All right, thank you. Yeah, the first thing I was going to say is that it was really hard for us to hear what the question was, and because the first question was so long, there was a lot of nuance that was missed, and I am assuming that the camera, like in the recording, also might have missed that. So that was the point that I appreciate you made. The second thing is that it seems like in the federal system, you were talking all about the federal laws and not the state laws, and you're getting into it a little bit right now, but the part of the design of the system seems to be allowing different states to try different things, and then the federal government can kind of see which works best and then apply that to, kind of like California leading the way on privacy, things like that.
Interesting point. This is actually an area where things actually work a little bit on its head for this reason. So what's developed over time is that the federal government is presumed to be the one that is most likely to actually pursue what would be a cybercrime, because often they have an international component these days, almost invariably, and that's something that basically states are not well positioned to address, let alone even if it's domestically one that reaches across state lines. And so it's sort of this particular type of crime, an intrusion or a disruption, is sort of tailor-made for federal government, intervention.
And just to quickly sort of do a quick paraphrase on the first question, it was basically the DOJ exemption looks at the sort of activities. It draws a box around to say, like, if you're a good faith researcher doing these kinds of things. And the question was, isn't it better to look at intent rather than specific set of activities, because bad guys could do those same activities. So that was that question. Okay, so then you had a question at the front.
First off, thanks for being here. So it's an idea and it's a kind of question at the same time. So there's a lot of regulations out there and laws where you have to get a license to do something. Like on federal land, you have to get a license to hunt. Can we not just have the good guys go get a license to do the good stuff? And then if the bad people don't have a license,
so let's put that to a vote in this room. I'm just curious.
Yeah. So I testified on this topic. I testified to Congress in 2015 on this topic, and one of the senators said the same thing. He said, "We'll just license researchers." The problem is a lot of discoveries are accidental and incidental. So what do you do about that? What do you do about the 5-year-old who figured out a way of hacking his dad's Xbox because he wanted to play? And it's unlikely that Microsoft's going to prosecute a 5-year-old. Instead, they actually gave him a lifetime supply of Xboxes. But the point remains, we see a huge amount of incidental or accidental discovery. And so we want to make sure that is also protected. I think the key here is to focus less on the concept of a researcher and more on the concept of research as an outcome. That would be my take on it.
I mean, and it's a good question, because the flip side of that is there's been questions about well, if I'm a security researcher, shouldn't I be exempt? And it's sort of on its head where we say it's not a status, right? You can't say, because I'm a security researcher, I can do things that will be destructive or invade people's privacy, right? And so it, as you said, I think it is really looking at what is the conduct rather than sort of the status.
Yeah,
of the individual.
I'm aware of a case at the moment where the public domain information on this is that poor researcher is being victimized by nasty company. The truth of the matter is the researcher has taken a copy of all the data and is holding it at ransom, effectively. That's not okay. You doing research for the greater good doesn't give you a get-out-of-jail-free card. It doesn't make it okay to do things like that. Leonard mentioned the Weave case earlier. They took 200,000 records and they sold them to Gawker. That's not research. You can't just say, I'm a researcher, therefore it's okay that I do these crazy things. In my view, my non-government view. Okay, so sorry, yeah, go ahead.
Good afternoon. So several attorneys general of recent memory, Jeff Sessions and Bill Barr included, but even going back to Eric Holder with respect to the San Bernardino shooting and the capturing of the iPhone, have made comments regarding end-to-end encryption and how it pertains to lawful interception and basically alluding to backdoors, master keys, weakening of entropy, however you want to phrase it. I'd be curious to know your read of the terrain as it exists today and perhaps how it might move forward, given that this conversation seems to be driven very much in the wake of catastrophe or references to any number of things that I think we all agree are reprehensible, but to which I think you get my point.
Sure. And I have an easy answer for this because I'm a cog in a very big wheel. And this administration has not yet taken a position on that. So I don't have, as an administration official, a position on that yet.
That's some nice dancing you just did.
I just work here.
Okay, so we're going to move on just because I know that people are interested in other policy topics and that there are other things that have happened. So let's get a quick update on the IoT Cybersecurity Improvement Act, because I think that this crowd care about IoT. So the act passed in 2020?
Yep.
Okay.
December 2020, yes.
And said, hey, NIST is going to figure out the details, which they did.
Yes.
And then what happened? It's like pulling blood from a stone. You speak.
Yeah. So, we were talking about this earlier. So this, like a lot of the things, for example, in the executive orders has, and also in the directives that have come out, things like the performance goals for ICS systems, required NIST and OMB to work on guidance that would be implemented. And one thing to remember about the IoT Cybersecurity Improvement Act is it was government focused.
Right. So sorry, how many people are familiar with the IoT Cybersecurity Improvement Act? Okay, so in a nutshell, rather than trying to move a broad piece of legislation to address all IoT development, Congress was savvy and thought, let's use the buying authority that the US government has to create behavioral change in the market that will then create a long-tail benefit. So the IoT Cybersecurity Improvement Act is specifically aimed at federal civilian agencies, right? Yeah. And their purchasing of IoT. And so...
So I'm going to use this point, though, to pivot to what I think is important. I really want to make, because I think it's a sea change in something we've seen in the last 2 years, and even from 2020. And that is, you're absolutely right that there is an issue. The thinking was that the government could drive the market and drive change in its purchasing power. What we've seen over the last year is a government that has a much greater appetite for regulation of cybersecurity writ large, right? So we've seen performance goals for ICS. We've seen reporting requirements that have been promulgated by the SEC, by the OCC, FDIC, and Fed. You've got CERCIA, which is going to have mandatory reporting for critical infrastructure for certain covered incidents. And these are things that were not happening. We actually attempted to get a data breach reporting law for about 16 years. And it essentially took what was a very bad year in cybersecurity incidents last year to really
you hadn't heard.
Move. And this is an area now, and this goes to also a place where I think you have an outsized voice, where there's actually kind of bipartisan agreement, right? There's actually a law on data breach reporting. And we've seen this in various other cybersecurity areas. We had the Cybersecurity Information Sharing Act in 2015. We had CISA authorizing statutes. We had authority given to CISA. That this area seems to be a place where, regardless of what political view people have or what administration, there's been a remarkable consistency across the last several administrations, from the Obama administration through the Biden administration, on critical infrastructure policy by and large. But I am suggesting that there actually is a change in that there is a greater appetite for actually regulatory authority in this area than we've ever seen.
And I'm going to give the last word to Jack. Is there anything that you think we've missed that we should have covered off?
There's so many things we could have covered. I think one area that hasn't been or has been mentioned in passing, but is President Biden's executive order on cybersecurity, which I think did both through some of the kind of leveraging purchasing power of the government or just kind of the government security itself and security of contractors, has also represented kind of a major shift in how the government treats cybersecurity. Includes a lot of stuff that this community has been working on, software bills of material, vulnerability disclosure policies, that we previously hadn't really seen coming at this level of policy making. So I would encourage people to check that out. There's a bunch of associated guidance that's come out related to that. There's going to be regulations, say, related to software bills of material that are kind of in the works still. But for instance, there's things like a zero trust strategy for the federal government. I would give that a read. You might be surprised that it includes a lot of things that probably many of us would agree on that we've never seen government talk about, say phishing-resistant multi-factor authentication, the idea that we actually shouldn't require people to reset their password every 6 months or something. So some of these kind of common sense technical policies finally bubbling up at the policy level.
Very good, thank you. So we're at time, so I'm going to wrap up. I'm just going to say, as the non-American in the room, a lot of these topics are also being looked at by other governments around the world, and a lot of the things that we talked about around how you can get involved and influence are also true for other governments. So if you are, like me, not American, you can still get involved, it's still relevant, and it's good to know what's happening in other countries, and Cavalry cares about that, right? Cavalry is international, not just US-centric. Thank you very much for joining us. We'll be around if you have questions.